Right to speedy trial. Right to speedy trial is a basic and fundamental features of judicial system. There is a proverbs behind this that if the justice delay, justice deny. But sometimes it prove wrong. अगर कोर्ट जल्दबाजी में बिना किसी प्रॉपर इन्वेस्टिगेशन के किसी भी नतीजे पे पहुंचता है या सुनवाई करता है तो इट मे बी वास्ट पॉसिबल दैट इनोसेंट कैन बी पनिश्ड, इनोसेंट कैन बी हैंग्ड. So there is a proverb behind this also that if the justice hurried, justice buried. So the balance between speedy trial and justice should be maintained. According to Supreme Court of India, the speedy trial is the essence of criminal justice. In USA, the speedy trial is a constitutional right guaranteed under the 6th Amendment of United States of Constitution. However, in Indian Constitution, the right to speedy trial is not specifically enumerated as a fundamental right, but it implies the broad view that contains Article 21 of the Constitution. In the case of Husainara Khatun versus Home Sessi, State of Bihar, the Supreme Court held that the right to speedy trial as a fundamental right that implied in the guarantee of life and personal liberty that enshrined in Article 21 of Indian Constitution. The Supreme Court of the view that the right to speedy trial is of the dimensions of the fundamental rights of life and personal liberty that guaranteed under Article 21. But the question whether the speedy trial was violated depends upon the various relevant factors. Thus, to determine the speed and delay, it depends upon the nature of case. Case कैसा है? If the case is belonging to murder, it could take time क्योंकि इसमें forensic report आना, there is a forensic investigation, murder investigation, वहाँ पे CBI बहुत सारी चीज़ें बैठती हैं, फिर जाके वो किसी नतीजे पे पहुँचते हैं. तो बात ये है कि वो केस कैसा है, उस केस को देख के हम ट्रायल कितनी जल्दी होनी चाहिए, कितनी स्लोली होनी चाहिए कि डिसाइड हो सकता है. बट डिले would depends upon the nature of case and the general situation prevailing in the country. No time limit can be fixed. It may be not interest of the justice. In our country, the fundamental right to speedy trial is a result of judicial activism to express respect to Article 21 of the Constitution. At the present, the right to speedy trial has become the internationally human right concept. This has become internationally human right concept. According to Supreme Court, fixing time limit for the speedy trial will prove harmful to how this possible. The court said that the criminal can misuse it by the dragging case for decades. On the other hand, the Supreme Court may have declared in the numerous judgments that supreme trial was intrinsic, the right to life of the accused. But the Supreme Court said that it was apprehensive about the fixing of time limit for the conclusion of the criminal trial as it could be misused by intelligent criminals. So they get the time. They get time. They can fix they can play with the proofs and the copies of the investigations if the criminal is intelligent. So it is noted that